Hey, Zach.
Hey, Ron.
You had some questions about tax?
I did. Now, I have some serious tax debt, and I'm looking to file a Chapter 7 bankruptcy. Will my tax debt be discharged in the bankruptcy?
Good question. It's a common question. A couple things that you need to understand right off the bat when it comes to tax is that what kind of tax are we talking about? If you're talking about your income tax, like for example your personal income tax, under certain circumstances your personal income taxes actually can be discharged in a bankruptcy. If you're talking about other things, like let's say you had a business where you owe some sales tax, that you're not going to be able to discharge because you were a trustee for that sales tax, and therefore you can't say personally, I'm not responsible for that kind of obligation. So when it comes to your personal income taxes, depending on if you meet the criteria, one thing is that you have to have filed your taxes, and you have to have filed 3 years ago. And if you filed 3 years ago and the IRS hasn't done anything successfully to collect from you, that would be one of the things that you would look at in terms of whether it's dischargeable or not. I have a 5 bullets that I wanted to review to make sure that you understand that there's some specific rules. The first one is that the most recent due date for the tax return must be more than 3 years old. That's a 3-year period, and it's computed from the most recent date that the tax return is due, and an extension to file the return will delay the start. So let's suppose that you had taxes that were due 3 years ago, but you filed them last year. No good. You have to have filed your taxes 3 years ago, and the 3-year clock after you filed has to run. Sometimes I get some people that come to me and they say, oh, I owe taxes from way back when, and I just did my return last year. And that the IRS hasn't had 3 years of opportunity to collect, so that's why you can't get away with that. All right, a tax return or equivalent report or notice, if required, must have been filed or given by the taxpayer for the tax year in question at least more than 2 years preceding the filing date of the bankruptcy. That's just a more specific rule that ties into the prior rule. The tax claim must have been assessed at least more than 240 days preceding the filing date of the bankruptcy. I don't know if you're familiar with this, but the IRS does what are called assessments. They assess what your tax is, and that assessment has to have been at least 240 days ago. Fourth, the tax in question must be free of fraud. The IRS has the burden of proving any kind of fraud. The tax return has to be accurate. It can't be anything made up or fraud-based. And then lastly, the taxpayer must not have engaged in any activity deemed to be a willful attempt to defeat or evade tax. You can't concoct your taxes in a manner where you were paying significantly less tax for wrongful reasons.
Right.
So assuming that you meet those type of criteria, you're okay. Most of the time people are under the wrongful assumption that they can't discharge taxes in a bankruptcy. So again, the key question is it an income tax? Did you file your taxes 3 years ago? And if the IRS has made, whether they have or they haven't made collection attempts against you, that's still outstanding, potentially could be discharged in bankruptcy.
Okay.
Right.
Well, thanks for the advice, Ron.